I'm Steve Akers. I'm with Digital Reef, which is a software vendor. We're based in Foxborough, Massachusetts, and we've been at it about 5 years. Joining me today for the panel are Jim Vaughn from iDiscovery Solutions, Gordon Calhoun of Lewis, Brisbois, Bisgard and Smith, and Brian Rocca of Bingham and Mifflin. So with that, we'd like to kind of launch into today's discussion. Social media, I mean, you probably are well familiar with it, but generally the definition is websites allowing collaboration and sharing large groups of people, sharing information. This has changed a lot in the last 5 years with the ascendance of Facebook and Twitter and the encroachment of those technologies into business communications. So we want to kind of dive into that today and look at all different angles of the issue. In the old days, we thought of collaboration as something that IT managed. We put up a SharePoint server, we put up Lotus Notes, we all put stuff up on it, but it was kind of within the corporate firewall. The employees using it were subject to the policies and procedures of the corporation. Now the world's expanded so that we're collaborating across geographies, across applications. One of the big issues is knowing who within an organization is even using some of these social media and these collaboration techniques, and whether they would do anything in a business context that would become that would generate a business record that might be pertinent to a litigation. So the world's expanded, and we have to worry about things like IP leakage, improper employee communications, and things of that nature. Because of the large number of these apps and the ubiquity of their use, it's multifaceted. There was one interesting article that I cite here about a prediction where Facebook communication would supplant business email. And if you think about the implications of that, they're very large, because big stand with your Facebook messaging or private and public messages. We're going to dig into that a little bit, the panelists are. But that becomes a knotty issue. Like, what do you have the right to look at? How do you tell business communication from a personal communication? And just getting at the data. Jim has some great insights and tools that you can use to help with that. But just all the societal and legal implications are very interesting. When you add in social media and the mobility of it, the fact we're using smart devices, iPads, iPhones, different devices, knowing who knew what when and where the messages all reside, it takes us beyond the world we're used to, where we're just collecting laptop images in a Windows type world. So the world is much wider. I hosted a discussion this morning where we were talking about different ways an iPad can contain a business communication, and the difficulties in getting at the data. Some of the other issues, like what happens when the service provider goes bankrupt. So the fact that communications can be in the cloud and on a mobile handheld device, and those devices have basic massive capacity to store information, it gives you a lot of headaches you didn't have 5-10 years ago. So with that, Gordon is going to go into some discussion around the growth of this and some of these issues.
I think the important thing to recognize is that people are going to find ways around procedures. So as a practical matter, adopting, as many companies tried when social media first became available, adopting a policy of prohibiting the use of social media for business purposes, that's a policy that's bound to fail. People are going to use social media to communicate. Even our federal government recognizes that stocks are bought and sold on social media, and therefore the regulated industries have to keep a record of it. The real challenge is finding out where that data is and encouraging people to apply reasonable behavioral guidelines to their use of social media for business purposes. Another feature that we'll see quickly is the explosive growth of social media. Mention was made that Facebook may supplant email. I think the studies indicate that in 2009, the number of Facebook communications on any given day exceeded the number of email communications. Since then, Facebook has grown larger, and there are competing additional platforms available. So, in simple numeric terms, there are far more interactions between people, including business communications, that occur on social media platforms than there are on email and other conventional means of communication. Some of the things we have to look at are ethical obligations of lawyers, what kind of policies we're going to adopt, and we'll end up with some discussion of best practices. It took about 38 years for the number of people using radio to get up to about 50 million people. It took about 13 years for TV to get to that size. Internet is about 4 years. Facebook was over 100 million in 1 year. So the rapidity with which these methods of communication are being adopted by the public are increasingly rapid. And the challenge for lawyers and the challenge for clients is, what's the next medium of communication going to be? Discovery Magazine has suggested that by 2015, over 80% of all communications, electronic communications, will be in the form of video. So there's going to be huge potential developments there. It's content rich. The size of those communications is huge compared to contemporary communications. So we're going to see a vast amount of changes in a very short period of time. And what management on the legal and the corporate side have to do is figure out how we're going to incorporate these changes in the way people communicate into our business policies. So again, on fast facts about social networking, over half the adults in the United States use at least one social networking platform daily. And we have a situation where 1/3 of employees actually access social networking sites while at the workplace. But only 10% of those companies have policies dealing with even something as simple as communications on social networking platforms shall conform to the company's code of conduct. Something as simple as that doesn't exist in 90% of the businesses out there. And to not have that minimal level of a standard is going to expose your companies to all kinds of problems in e-discovery situations. Where does that line between personal and business get drawn? If the company doesn't even have a policy dealing with the issue, it's going to be awfully hard to be able to draw a line and limit and protect your employees. How far into their social networking platforms are we going to have to go if there's no guidance or standards out there? The other thing, and this goes to having a simple standard like it will conform to the company's code of conduct. Only 8% of people using social network platforms have ever read the privacy policies associated with the platforms they're using. Almost half the people who use them don't care what's public and what's private. So you've got a huge, huge risk and exposure if you're simply putting your head in the sand and ignoring these problems. Currently, about 15% of companies are comfortable with their ability to capture their employees' use of social media to conduct business matters. That contrasts starkly with the 87% that are comfortable that they can collect conventional email used for business purposes. So there's a huge disconnect here, and the fact that people are using the social media more often, in fact, than they're using conventional email suggests that there's a real problem for those of us who are on the litigation front acting on behalf of our clients. The public-private boundary is really difficult to establish with social media, which again points to the extreme left-hand side of the EDRM model. What are your information management protocols and practices? I think we mentioned in the last session, best practices session, that the EDRM model probably provides you with a roadmap for dealing with virtually any type of problem. So here we have a new media, social media, and we have a question. How do we manage that? Well, the first thing has to be the adoption of policies, procedures, and protocols. Some of those things can help define the difference between a business and a personal message. Keep your employees' private matters out of business discovery and a litigated dispute. So the bottom line is adopt consistent policies, have those policies sufficiently generic that they apply to all lines of media and communication. There will be new methods of communication that will develop almost overnight, and if you don't have a policy, you will have a problem. So go generic and deal with modes of communication and have your standards deal with those. Issues lawyers have to confront are, among other things, our obligation to preserve evidence. That means we have to ask the right questions of our clients. How is business being conducted? It's not enough to get the answer from someone in the C-suite. Well, we have these prescribed methods. We use paper correspondence. We use emails. We have various other intra-company methods of communication. We have our own private cloud we use to collaborate. That may describe what management is aware of. You're going to have to dig deeper and find out what people actually do. What are the people who are on the front line in sales? How are they communicating with their customers? It's not going to be just company email and formal letters. People are going to be tweeting, they're going to be texting, they're going to be using social media, they're going to be using LinkedIn. Some of them will have Facebook postings. There will be all kinds of ways that information is actually coming into the company. And we as lawyers have an ethical obligation to find that out. Failing to do so, as Browning mentioned in the last session, could expose you in a gross negligence situation to a bar proceeding, which could threaten your livelihood. So the questions have to be asked and have to be delved into. Then there's questions of, now that you've found out all the ways that data is coming in and out of the company, is your client compliant with the various federal and state regulations that regulate your industry? How about in the healthcare sector? You've got HIPAA and HITECH. HITECH is going to overlay all of your electronic communications. You have to have an ability to log those communications. Basically doesn't exist in the standard format. There are programs and hardware coming online that will allow for the integration of all these communication methodologies and create an archive of that. But people have to be thinking about where's the technology going, how is it going to aid me to do that which the law already requires me to do. So there's going to be questions when you find out that there's non-compliant methodologies of communication. The real threat to your client may not be the litigation that's resulting in your finding out that there are these non-compliant methodologies of communication going on. The real threat may be to federal agencies or state agencies because you are out of compliance with your obligations. There's also other ethical issues. Think about, in the trial context, of checking up on jurors or jurors checking up on parties. Think about the creation of a false identity to friend an adversary in litigation. That issue's already been addressed and it's strictly forbidden. You cannot, as a lawyer, engage in the practice of eliciting information from an adversary through a pseudonym. In other words, there's no friending of adversaries in ethical litigation. Because of the problems with communication, you have to think about what kind of jury instructions are you going to want the judge to give to make sure people don't go to social media sites to do their own investigation. These are things that are not dealt with in the standard jury instruction.